There's one thing everyone is getting wrong in the discussion about race-conscious admissions and the Supreme Court's decision in SFFA versus Harvard. And that's who affirmative action is designed to benefit. And no, I'm not talking about white women. The whole thing is driving me crazy. Look, the important thing to remember that affirmative action, what we're calling affirmative action, more narrowly the race conscious admission policies of schools like Harvard or North Carolina, is that the policy was never about Harvard giving reparations or about ameliorating past wrongs. It was never about giving black people or students or other people of color a step up. And listen, I'm not saying this is my position. Please don't misunderstand that I'm in favor of any of this nonsense. But it's important that everybody understand what the previous Supreme Court has ruled in prior decisions. Race conscious admissions was never about helping minorities be competitive with white people or rich white people in the marketplace. It was always, at least since 2003, about letting white people who are in these schools, especially the rich white people whose parents also went to the same school, and letting them learn from people who otherwise were not going to be admitted into the schools. That's right. The purpose of collegiate affirmative action was to benefit the students who were already there, not the historically disadvantaged that wanted to get in to better their lives. That's just a byproduct. That's not the feature. My name is Marcus Landsberg. I'm an attorney on sabbatical. And for those who have been with me since the beginning, you know I'm back to filming in my bathroom. Don't make fun. Back to the story. Quickly, in 1978, the quickest history, the case's name is Bakke. The court landed a very rare tie about using race as a decision maker to remedy disadvantages cast by minorities by past racial prejudice. The tiebreaker basically said attaining a diverse student body was the only reason the university suggested in the legal case that may possibly be legal under the Constitution. I'm paraphrasing a little bit, but I want to make it standard English without getting into all the different types of strict scrutiny, intermediate scrutiny, all that kind of thing. The case we have to talk about is Grutter v. Bolinger, that's 2003. And it adopted at that point of view that made explicit that the purpose was a, quote, critical mass of any particular minority of students. The purpose of diversity in college admissions is not about benefiting historically prejudiced classes. It is to create that critical mass of every particular group that the students were already being let in could then learn from, that they could suck knowledge from them. What was the purpose of diversity in these schools? The best example I can give you, and it's a little bit roundabout and it's not exactly academics, but the best example I can give you is if you remember the famous Gap commercial where LL Cool J showed up and he was paid a lot of money to rap over, it was either a basketball bouncing or a very sparse beat, and in black and white video about why all kids should wear Gap jeans. Here's the thing. At the commercial, he showed up with a FUBU hat on and he rapped "For Us, By Us" on the low. That's what launched FUBU into the stratosphere. But nobody from Gap, and let's be clear, nobody on the set, the director, nobody at the head office, no other people, anybody in the advertiser's room who came up with the ad, who hired him to do it, anybody higher up, nobody knew that when he said "For Us, By Us" on the low, he was advertising the other brand of the hat that he was wearing. Nowadays, we all know. But because there wasn't anybody in the room at the time, in the room where it happened, so to speak, who knew what the FUBU logo was, since no one knew what he said "For Us, By Us" on the low, that didn't ring any alarms. If they had one black person in the room, one person who knew the culture, or better yet, if they had a critical mass who would feel comfortable saying together, hey, isn't that a different company? That issue would have been solved and it would have been the major blow to Gap, which that commercial ended up being. Let's talk about what a critical mass would do. The reason Grutter talks about a critical mass is that no one black person, no one minority of any specificity, if we use that phrase, people of color, is representative of all people in their group. If you're ever in a class with one minority or with 6 or 10 minorities, you can see the difference during the discussion. If you're in the class with one person of a particular background, you'll see they feel the pressure. Now they have to answer for all people. They basically have to represent everybody of that skin color. And that's the fake image which they're told to put on, which they have to put out front. And so they don't have to answer hard questions about what's really going on behalf of all their people. But if you have 6 or 10, then you start to get disagreement. Then you start to get people who say, I no longer have to carry the weight of my whole community on my back. I can give you my opinion, what I learned from my uncles, and someone on the other side of the class with a similar yet different background can say, no, here's the lesson I learned from that. It's these intra-community conversations. These are the ones that's the diversity of the schools, Harvard in particular, wanted their kids, their students to learn from. Oh, I got one for you. Remember Little John did a song, what was it? Skeet, 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 skeet. Skeet so much they call me Billy Ocean. David Chappelle did a whole bit. I think it was on his show. Most of you may be too young to remember the whole bit, but he said, how'd they get this on the radio? Must have had no black people in the room to tell them what skeet meant. Now we have skeet everywhere. Everything's covered in skeet. You have Skeet Davidson. You have skeet all around us, skeet on everything. But the joke that Dave Chappelle told was that since there's no black people in the room, that song got past the censors. Ha ha, we got one over on you. Again, that's the argument for diversity here, not to benefit the historically discriminated people. It's to benefit the people who don't otherwise understand the historically discriminated point of view, or the point of view of the people who have been historically discriminated. So I understand that the 2 examples I gave you are not in an academic institution type of setting. But there's legal cases. Shelley v. Kramer is a big one. Maybe the discussion of Roe would benefit from diverse viewpoints, obviously. But there are cases where white people, just because they haven't been in certain situations, don't, and I mean, obviously, generally, because no one's a monolith, but the types who get into the high level schools because they have the time and the ability to apply themselves to study programs to get there, or to have people tutor them to get there, that they don't understand exactly what's happening because it's not always explicit on the legal page because the judges don't address it in such a way explicitly. You need those students to be able to bring it up. You need the oral history, the spoken history, maybe the genetic history, in order to understand these things. And this is all my way to tell you, keep in mind that college admission, and I'm not talking about workplace affirmative action, that's a different story with different ramifications, but the purpose of diverse admissions was to help the rich white people already in the school. It was never for the benefit, at least not since I think 78, it was never for the benefit of people receiving the invite to the school. It was always for the people who are already being invited. And as a side note, I would mention the final takeaway from this case is keep in mind in 2023, there's certain states where it will be illegal to teach Justice Ketanji Brown Jackson's dissent, as it may just cross the line into something that's too close to CRT to be comfortable in many of these states. To me, among everything else, that is a travesty. Thank you always for listening to what I have to say.